Welcome back to the Law Show. Bob Kerrigan with you from our broadcast studios here. Kerrigan, Estes, Rankin, McLeod, and Thompson, the sponsors of this program. I'm one of the partners with the law firm. We've been here in the North Florida area, Northwest Florida primarily, but across North Florida for years, and have established a practice that focuses on trial work, and that's in the courtroom. That's where we are with our cases, and our cases generally involve serious injury or death claims. I've said this many times in the past that years ago you had to pay a lawyer, had to give a lawyer a retainer, a certain amount of money to prosecute your case. In today's environment, the cases are expensive, especially medical malpractice cases. They're just very expensive. And so our firm has decided that we will advance all costs of these kinds of cases, and we will not expect reimbursement for those costs unless we make a recovery, and we won't be paid until we make a recovery. We don't send the clients bills as the cases are progressing. And when the case is concluded, we expect to be compensated according to the contract that we enter into with the client. The contract we use is a contract that has been approved by the Florida Supreme Court, and it provides a percentage of recovery depending upon various stages of the case and the amounts of money involved. The greater amount of money, the lesser the percentage recovery for the lawyers. So in multi-million-dollar cases, it's much less than it would be in a standard contingency fee case involving a typical automobile accident case. You have a right to understand everything about what the lawyer is going to do, what kind of experience the lawyer has, what kind of training the lawyer has, the reputation the lawyer has. All these questions should be asked by you. The Florida Supreme Court has done a good job, I think, in establishing a list of clients' rights. These are rights that you have before you talk to a lawyer to make sure that the kinds of questions you are asking the lawyer, that you get good answers that allow you to make an informed decision. We don't charge anybody for consulting with them about a case, and we don't create a sense of obligation. So as soon as they come into our office or see us, we hand them papers to sign. I mean, we are the lawyers. We know what these contracts mean and what they provide. So we like to give them to the client, give them plenty of opportunity to look over it, read it, try to understand it, ask any questions they have. We will write on a contract itself anything that they want us to write on the contract that allays any fears they have about the fee that they're going to have to be paying at the end of the case. We try to do this in a way where we never have a conflict with the client at the end of the case, because when you work hard and you worked on a case a long time and you get a good results, you want it to be crystal clear what the compensation is going to be and what the client is going to receive. When we go to a mediation, we have talked here on the Law Show about mediation. That's basically an informal conference where you try to settle the case. Before we end mediation, where there's been an offer, we will put in writing what the client is to receive as a result of that offer, so that there isn't a situation where you reach a settlement, say a settlement is $100,000, and then later the lawyer explains how he's got additional fees or charges or costs or something that you didn't know about at the mediation, and therefore your percentage will be less than what you thought it was. We don't do that at mediation, and I highly recommend this to any of you that are going through a mediation with a lawyer. Just explain to the lawyer that you want to know in writing. If you agree to a settlement, you want to know in writing with the lawyer's signature and your signature what you will receive. In other words, what will the check be that I'm going to receive? The lawyer should provide that to you before the mediation is over, so that in mediation you're going back and forth discussing settlement, trying to figure out what we can resolve the case for, what the other side is willing to pay, what you're willing to receive. and you come up with a figure, as I said earlier in that example of $100,000, you need to know before you walk out of that mediator's office how much your check will be. And you can tell the lawyer before you go to mediation that that is something that you're going to want to do. You're going to want to have that in writing. We do that routinely because when people go through the stress of one of these cases and you get near the end and you've settled the case and people are satisfied, usually mediation, nobody's really happy about it. The other side paying more than they want and the person is really receiving probably less than they had hoped to get, but it gets settled. It's over. You have a sense of relief and the stress that you've been through going through the mediation process, going through the litigation process. You should know exactly what you're going to get paid, okay? And in the final payment to you, there should be a distribution sheet that will, or page, that shows you precisely what the costs were in the case, what you are paying to the lawyer in terms of a fee, and then that figure at the bottom, the net figure, will be the figure that you were told in mediation you could expect to receive. Okay, so that's how that works. And just for those of you who are going to go through mediation in the future, I hope that helps you some, because confusion about money is not good. And lawyers are obligated to make sure there is no confusion about the amount of money that you're going to receive, because it's your case, not the lawyer's case, it's your case. But I want to make a couple of comments now with the time that I have. I've talked in the earlier session about how we are going to continue to try to understand this Medicare thing and to understand the complexities of it, why the government does not have a sensible way for you to read all of these plans online in writing. If you try to find these plans in writing, you can't find them. We're going to explore that. We're going to explore why private insurers are involved in Part D, these drug plans, why that wasn't undertaken by Medicare. My fear is that private insurers are going to completely take this over, and that these policies will be so confusing that people are going to sign up for them and not realize until it's too late, until they're in a claim, that they are in the wrong spot. Okay, we talked about the commercial, the highly misleading commercials that have been run. Many commercials, I think, are not misleading about healthcare advantage plans. They say pretty straightforward, this is our plan. We're going to provide that. We're going to provide drug coverage. We're going to quote you a premium and all. The problem is the public doesn't understand the complexities of this, and to understand that you're not getting Medicare. You're getting something else. You're getting a substitute for Medicare. But what I want to address now, and it preys, I say on the elderly, I'm one of them, so it's not like picking on a group that I'm not a participant in, but I think it's difficult for people who don't have any experience with this to really understand the options that are available and to make an informed decision, because you don't know what kind of illness or disease you're going to have. And that's the whole problem with these Medicare Advantage plans. You do not know what you're going to run into to see how it's going to be affected by the policy you've purchased. But I've talked about that some earlier today in the last couple of weeks. By the way, and I am so appreciative of those who've taken the time to send us a text message. Or text me right now. We'll answer your text messages while we're on the air. It's 850-444-4444. That's our phone number, too. You can reach us in that phone number. But for texting, you have to do the 850 before there. So I want to talk about just the whole industry of the exploitation of the poor and of the elderly and disadvantaged and people who are not able to sort through what's being said to determine what is true. Let me give you an example about an advertisement. So this company, they sell furniture and they advertise no interest till 2022. Great, no interest. So you kind of run it through your mind. Wow, I mean, I have no interest, and so every payment I make will be knocking the principal down. It's just great, okay? But in the fine print, they tell you that if you are late, interest accrues immediately. and there is no free interest. You've lost it. And so you send a payment that's late, you're short that month, you had to take care of a vet bill or, something for the kids or whatever, and you send it late. Now you're back into this awful interest that they charge. And I mean, some of it is just prohibitive in terms of the amount of interest compared to, say, what you could borrow from a bank. So you have to understand that what's being advertised as free is never free. It's never free. It's always got a hook. You say, well, yeah, but if you make your payment on time every month and you never miss, well, that's true. That's a fact. In that case, maybe it is free, all right, at least for that period of time. But most of the time, there's a little hook of some kind in it. But to me, the most egregious thing that is going on for exploitation of the poor, and you can judge the poverty of a community by the number of payday loan stores and title loan stores. You judge a community's poverty level by the number of those. It's a pretty good indice of how poor a community is if you see a lot of these payday loan outfits and title companies. There's a commercial going on right now that people are jumping up in the air and they're waving their hands. They're so happy they got their title. They say, I got my title back from so-and-so. I got my title back. I got my title back. Well, what does that mean? It means that they've paid a loan off to get the title back. Well, what are the loans amount? Okay, up to $2,000, 30%. $2,000 to $3,000, 24%. Over $3,000, 18%. And these are virtually guaranteed loans because you've given them the title to a vehicle that's worth 3 or 4 times what they're loaning you. And these interest rates are 30%. Okay? You want to go borrow some money from a payday loan place? You got somebody working hard, making $8, $10, $12 an hour, whatever they're making. They get a loan up to $1,000. The actual interest rate, 304%. 10% for every $100. Preying on working people, preying on the elderly, preying on the disadvantaged. I don't understand why churches and nonprofit groups don't establish for our working people advance payments against paychecks from legitimate companies so that people that are working so hard don't get faced with these high interest rates because they're short of money for the kids or for Christmas or for a doctor bill or for gas or whatever they need. It just would be wonderful if we had nonprofit groups take a look at this in our community and try to help people who are helping themselves and working hard but being exploited to the point of these enormously high interest rates. So I hope you'll think about that and send any comments you have about subjects that we can cover. We welcome contrary opinions too. We're not happy about them, but we'll publish them if you send us a contrary opinion or a view that is different than what's been expressed here. Bob Kerrigan for Kerrigan, Estes, Rankin, McLeod in Thompson. You can reach us at 850-444-4444 by text. And that's it for this segment of the Law Show. We'll be back after this commercial message. I'm Bob Kerrigan. Have you seen the young lawyer advertising standing on top of a truck? I wonder who he would hire if he fell off the truck. Maybe the lawyer who has hundreds of billboards up and down the interstate. If it happened in Florida, though, it couldn't be him because he doesn't even have a Florida law license. He wouldn't hire the lawyer who barely has time to eat with his family because he just seems too busy. Maybe the lawyer who busts down his office wall, but that may not be a good place to be if another wall is crashed through. If he called us, we'd tell him it wasn't the brightest idea to climb up on top of the truck in the first place. With the highest ethical and legal ability rating from Martindale-Hubbell. We represent one client at a time, and we've represented thousands of clients over the years. Your case will be handled by a board-certified partner, board-certified in civil trial by the Florida Bar. Kerrigan, Estes, Rankin, McLeod, and Thompson at Kerrigan.com.
Good Sunday morning to you. My name is Randy Thompson. I am one of the partners at the Kerrigan law firm. I'm glad you're watching us this morning. And I would like to talk to you a little bit about Florida's dog bite laws. Let me give you some statistics concerning dog bites that may interest you. Approximately 4.5 million dog bites occur each year in the United States. The percentages vary, but somewhere between 50 and 70% of those victims are children. Nearly 27,000 bite victims have to undergo some sort of reconstructive surgery as a result of the attack. In the 15-year period from 2005 to 2019, dogs killed 521 Americans, and pit bulls contributed to about 66% of those deaths. The average cost of a dog bite-related hospital visit is $18,200, which is about 50% higher than the average injury-related stay at a hospital. Homeowners insurance carriers paid out $797 million in liability claims to dog bites and other dog-related injuries. You know, sometimes dogs take off running and knock people down, and so that $797 million not only includes dog bites, but other dog-related injuries. So it's a significant issue in the United States, dogs and dog bites and liabilities of the owners. So let me talk to you a little bit about the law in Florida and how it applies and where it came from. Originally, our laws came from England, and we call it common law. And so English common law early on decided that in order for a dog bite victim to be compensated by the dog owner, the victim had to prove not only who owned the dog, but that the dog was dangerous, and that the owner of the dog knew the dog was dangerous because it had bitten someone else before. And then, of course, the victim had to prove their damages, how they were injured by the dog, the amount of medical bills, the amount of future medical treatment, drug prescriptions, antibiotics, that type of stuff, scarring left. But under common law, it was known as the one free bite rule. In other words, a dog owner wouldn't be responsible if you were the dog's first victim. Well, our Florida legislature ultimately decided to change those laws, and they enacted the first changes to common law in the 1890s. And in 1949, our legislatures came up with what is currently Florida Statute 767.04. So you can go into our statute books and you can look at Florida Statute 767.04. Now, it's gone through a lot of revisions and changes from 1949 until now. I think the most recent amendment to the statute was in 1997. But here's what our current Florida statute says about dog bites. The owner of any dog that bites any person while such person is on or in a public place or lawfully on or in a private place, including the property of the owner of the dog, is liable for damages suffered by persons bitten, regardless of the former viciousness of the dog or the owner's knowledge of such viciousness. All right? So that first sentence does away with the one free bite rule. And our court said, well, wait a minute now. If you've got the owner of a dog and some innocent victim who probably doesn't know the dog, shouldn't the burden of the medical expenses and the cost associated with a bite be on the owner of the dog? So it starts off with, all right, we're doing away with the one free bite rule, and the owner of the dog that bites any person is responsible for the damages regardless of whether the dog had ever bitten anyone else. But the legislators went on and they added this. However, any negligence on the part of the person bitten that is a proximate cause of the biting incident reduces the liability of the owner of the dog by the percentage that the bitten person's negligence contributed to the biting incident. All right, what does that mean? It means comparative negligence applies to dog bites. So 6 people on a jury would be asked, well, wait a minute now. Okay, the dog bit, but here's what the victim was doing. He was teasing the dog. He kicked the dog. He startled the dog. He was tempting it with food or whatever, right? So the comparative fault of the person who gets bitten comes into play. Our legislature went on to say these things. However, the owner is not liable except as to a person under the age of 6, or unless the damages are proximately caused by a negligent act or omission of the dog owner, if at the time of any such injury the owner had displayed in a prominent place on his or her property a sign easily readable, including the words "bad dog." All right, what does that mean? So that means the legislators said, all right, but wait, if the dog bite occurs on your property and you have an easily readable, identifiable sign that include the word "bad dog," then the owner of the dog is not responsible unless the victim is under 6 years of age. Okay, well, why is that exception there? Our court said, well, children can't read. I mean, at certain levels, young children, especially under the age of 6, aren't expected to be able to read. So we have that exception in there. But then the legislators went on and said, so if you have a dangerous dog sign on your property, and if the victim is over the age of 6 years old, you still may have some liability if at the time of the injury the owner did something wrong, some omission. What does that mean? There are cases that have been decided by our courts that say, well, wait a minute now. People were invited to a birthday party, and at that birthday party, there were signs up that said "dangerous dog." And the guest said, well, what about these signs? What about these signs? Oh, don't worry about those. We just put those up just to keep people off our property. Don't worry about it. Come on in. The guests come on in, and sure enough, they get bitten. And our courts have said, nope, you don't get to escape liability by having a warning at one hand, but on the other hand saying, oh, disregard it, don't worry about that. There are also other examples where a person who doesn't necessarily own the dog, but knows that the dog is out and loose and around, and allows that dog onto the property, and then that dog bites somebody, that homeowner, even though they don't own the dog, if they allow the dog to be there, if they're the guardian of the dog, if they are taking care of the dog, if they know that the dog is there, then that homeowner, even though they don't own the dog, may very well have liability under an insurance policy. The question then is whether the owner of the property has any insurance, and if so, whether that insurance excludes dog bites. More and more now, these insurance companies, homeowners insurance companies, are refusing to provide insurance coverage for dog bites. And so it's specifically excluded. Or when you take out your homeowner's insurance policy, they ask if you have any dogs. And if the answer is yes, then your premiums go up, or they choose to exclude those dogs and any dog bite claims or dog injury claims. So that's some of the basic background of Florida's dog bite law. My name is Randy Thompson, and again, I'm one of the board certified civil trial specialists at the Kerrigan law firm. You can find more information about us and our law firm at Kerrigan.com. And of course, you're always welcome to email us or call us, and we will do everything we can to try to answer your questions for you. One of the things I'm most proud about and that I talk about a lot is the fact that this law firm is made up of the 5 attorneys that you see on our letterhead, on our billboards. We don't have associates. We don't run a mill where we try to shove as many claims through the process as we can. If you hire me, I'm going to be your lawyer that represents you. It's not going to go down through some other associate or law clerk. It's going to be me. And that's an important thing, that you know your lawyer, that you speak to your lawyer, that you have a contact person so that you can reach out when you have a question to try to understand what's going on. So again, I am Randy Thompson. Our law firm is Kerrigan, Estes, Rankin, McLeod, and Thompson. We bring these shows to you on Sunday mornings, hopefully to give you some education about the legal process. And again, we are always happy to speak to you, either by email or by phone call or text. So please, if you have any questions concerning your legal rights in the state of Florida, concerning personal injury claims, and in this case, dog bites, I'd be happy to talk to you and happy to try to answer any of your questions. Thanks for watching the Law Show, and we'll be right back after this brief commercial break.
For over 30 years, we've been part of this great community. Kerrigan, Estes, Rankin, McLeod, and Thompson, representing accident victims across Northwest Florida. For over 30 years, we've been part of this great community. Kerrigan, Estes, Rankin, McLeod, and Thompson, representing accident victims across Northwest Florida.
Good morning to you again. I am Randy Thompson. I'm one of the board certified civil trial specialists at Kerrigan, Estes, Rankin, McLeod, and Thompson. We are a personal injury law firm. It's only the five of us. We don't have any associates. So if one of us says we are going to help you, it's going to be one of us that's going to help you. I'm kind of proud of that fact. We are not a warehouse just trying to run a number of cases through where we never meet our clients. That's not what we do. That's not what this firm was built on. And when I say we are board certified trial specialists, I'm kind of proud of that too, because I think about only 2% of the attorneys in the state of Florida are board certified. You have to take extra tests. Judges have to comment on your abilities and your qualifications. And so I'm kind of proud of that too. But again, I'm Randy Thompson. I am the bottom of the barrel. I'm the last name in the law firm. And this morning I'm going to talk to you a little bit about what is your automobile accident case worth in the state of Florida. How do you know what the value of your personal injury automobile case is worth if it happens to you in the state of Florida? And the answer is, ultimately, if your case can't get resolved through settlement or negotiation, then 6 people on a jury are going to tell you what the value of your claim is. And whether you agree with them or don't agree with them, they're going to tell the defense, the people that caused the accident, and they're going to tell you and your lawyer what they think the value of the claim is. And generally speaking, those 6 jurors, their opinion about the value and the merits of the claim are not overturned on appeal. Appeals happen oftentimes because judges give jury instructions that the appellate court says was wrong, or one of the attorneys, either for the plaintiff or the defendant, says something or offers a piece of evidence that was incorrect. And so appeals happen and jury verdicts get overturned and reversed, and you come back and try the case again. But generally speaking, if 6 people on a jury say that the value of your claim is $100,000, no appellate court is going to overturn it just on that fact alone. Now, the vast majority of cases, these car accident cases, never get to a jury. I think probably 85% of car accident cases get resolved short of a jury trial. But in order to understand what the fair value of your claim is, you have to be able to understand what a jury is likely to do with the information they're given in a case like yours. And so that's another reason why you would like to select a board-certified civil trial attorney, an attorney who only focuses on civil trials and trying to get people fair compensation for injuries caused by someone else. And that's, of course, what our firm does here at Kerrigan, Estes, Rankin, McLeod, and Thompson. So, ultimately, the value of your claim is decided by 6 people on a jury if it can't get settled. Well, how does a jury decide what the fair value of your claim is? They're read instructions by the judge who's trying the case. And so once all of the evidence has come in, the judge will read the jury instructions about how they're to come about their decisions. And then the judge will give them, at the very end, a verdict form. And we're going to put it up on the screen for you. This is a Florida standard jury verdict form. It's a 2-page form. There's 7 questions on it. And I'm just going to go through them because it'll give you an idea of what 6 people on a jury would do if your car accident case got in front of them. So the first question that the jury is asked to answer is number 1. Was there negligence on the part of defendant Rachel Rowe which was a legal cause of damage to plaintiff John Doe. So in this example, the person that caused the accident is Rachel Rowe. She's the defendant. And the person that is injured, the person that got hurt in the accident, allegedly, is John Doe. And so the very first question the jury is asked is, well, did the defendant do anything wrong? And so let's say that the jury decides, yes, they did, that Rachel Rowe was negligent, and her negligence was a legal cause of the damage. So they check yes to that. And then the very next question they're asked is, well, did John Doe do anything wrong? So question number 2, was there any negligence on the part of the plaintiff, John Doe, which was a legal cause of his damage? Well, so if John Doe was sitting still at a red light, minding his own business, and his brake lights worked, and he got plowed into from the driver behind, no, there was no negligence on part of John Doe, you would think the jury would conclude. But let's say that there's evidence that the plaintiff, John Doe, might have been speeding. He might have been going 10 miles an hour faster than the speed limit. So a jury could decide, well, okay, well, the plaintiff, John Doe, was partly at fault in this accident. So let's say that they check yes to number 2. And then we get to the third question, which is, tell us what is the percentage of fault that you place on Ms. Rowe and on Mr. Doe. And those percentages can be whatever the jury decides them to be. They can be 90% on Rachel Rowe and 10% on John Doe, 95% to 5%, as long as they total up to 100%, whatever those numbers are, they can be 50-50, 70-30, 30-70, whatever those numbers are, the jury can write those in there. And again, no appellate court is going to overturn that. So let's say that the jury decides that it's 70% Rachel Rowe's fault and 30% John Doe's fault. Then the judge gets to the next question, which is damages. How has the plaintiff, Mr. Doe, been injured? And so question number 4 is, what is the total amount of John Doe's damages for medical expenses incurred in the past and medical expenses to be incurred in the future? Now, a lot of instructions will go along with these individual questions. The judge will read instructions, but in order for the jury to have numbers to put in that box, it has to come from expert testimony. It has to come from the doctors who say, I believe within a reasonable degree of medical probability that Mr. Doe will have to have these procedures in the future because of this car accident, and testimony about what his past medical expenses were. And then question number 5, what is the total amount of John Doe's damages for lost earnings in the past and loss of earning capacity in the future? So if his injuries caused him not to be able to work, and he can show that evidence and produce that evidence, a jury will consider that, and they will decide whether to award damages for that and whether the car accident caused that. And as far as future earning capacity, let's say the doctors say, well, you're going to have a surgery. Well, so we know you're going to be out of work. So we can project future lost earnings. And so those numbers go in there. And then question number 6 in Florida is important because it goes to intangible damages. Question number 6 says, did John Doe sustain a permanent injury? I could spend several shows talking to you about permanent injuries, but in this section, what I will simply say is a doctor has to say that as a result of this car accident, the client has either sustained a permanent injury or a permanent aggravation to a pre-existing injury. If the answer to that question is yes, did John Doe sustain a permanent injury, then the jury goes on to answer question number 7, which is what we call the intangible damages. How your life has been changed and altered and devastated in certain circumstances because of the fault of somebody else. And then the jury goes and they add all of those numbers up. They add all of the blanks up and they come to a bottom line number. But then the judge, in looking at the comparative negligence, reduces the amount of damages that John Doe would recover, in this case, by 30%, because the jury decided that he was 30% at fault. So he only gets 70% of his medical expenses. He only gets 70% of his lost wages. He only gets 70% of his intangible damages, the damages that the insurance companies make such light of by saying pain and suffering. But until you've woken up every morning and your back still hurts, or your leg is still on fire, or you still have a stiff neck years after an accident, and you never had it before the accident, you understand how significant these types of injuries can be and how they play out as we age and as we go through our life. Typically, as we get older, we don't get healthier. We need health care more, and we need to see doctors more, and more things hurt us. So to have an attorney who specializes in civil trial cases, who knows and understands the jury instructions, how they work, when they work, which ones apply, which ones don't apply, and know the information that 6 people on a jury have to hear in order to help you receive adequate compensation in your case. So that's a brief overview of what jurors try to do when they are looking at cases, and what I, as a board certified trial lawyer, tell the adjusters the jurors are going to do and how they're going to respond. So again, I'm Randy Thompson. I'm one of the attorneys at Kerrigan, Estes, Rankin, McLeod, and Thompson. Our phone number is 850 and then all fours, 444-4444. You can reach me at randy.thompson@kerrigan.com. And I would encourage you to check out our website, kerrigan.com. We've got a lot of information about the attorneys, about the types of cases that we handle. And we're glad to talk to you. We represent you on a contingent fee basis, which means it doesn't cost you any money to talk to us about your case. Feel free to call us.
Bob Kerrigan for Kerrigan, Estes, Rankin, McLeod, and Thompson. What is medical malpractice? In many ways, it's similar to an auto accident. If a driver of a car is careless and causes an accident and injures someone, the driver is responsible for those injuries. If a doctor or employees of a hospital violate the rules of medicine, they're responsible for the injuries they cause. These rules of medicine make up the standard of care that doctors and hospitals are required to follow. Medical malpractice cases are expensive to bring and can be very difficult. We're required to retain qualified medical experts to assist the jury in understanding why what was done violated this standard of care. At Kerrigan, Estes, Rankin, McLeod, and Thompson, we accept meritorious medical malpractice cases where substantial injuries or a death have been caused by a doctor or a hospital failing to abide by the rules of medicine. Please see our reviews on our website at kerrigan.com.
Welcome back to the Law Show. I'm Mike McLeod, and I'll be with you for this next segment of the show. The Law Show brought to you by the law firm Kerrigan, Estes, Rankin, McLeod, and Thompson. Proud to host the Law Show every week at this time on this station, and we hope that we provide helpful information about both consumer topics of interest, but also a little bit about our law practice and our specialty, which is representing people and families who've been affected by and seriously injured in accidents of all types. Our firm specializes in representing people who've been injured in automobile accidents, the subject of medical malpractice negligence, cases where people are injured on premises of other people's businesses, and dangerous products. And we've limited what we do, all the other helpful and good things that lawyers do, helping people with estate planning, business decisions, business organization, estate planning, divorces, criminal defense work. We just decided decades ago that we were going to specialize just in the personal injury business. And I will say, long before you could ride through town and see billboards from 8 different law firms, our firm, well before that time, today, specialized and limited what we do only to representing people who've been injured in accidents. We've done it for a long time, and we are board certified specialists in that area, and we've lived and worked in this area for a long time, and we're very proud of the thousands of clients that we've helped over almost 40 years. So for the last segment of the show, we're going to go to the mailbag because our setup here allows us to get questions from you and answer them by text and also by email. And so we've got some of those that I'm going to run through here at the end of the show. And I will say again that the best way to communicate your comment about the show today, or a question about something that you see on the show today, or just a question about accidental injury cases, is to text us at our main number, which is 850, and then it's all fours, 444-4444. That's our main telephone number, answered 24/7. But you can also text us at that number. We'll receive it. We'll answer your question if it relates to something of interest. And also, you can comment through my email address, which is on the screen now, mike.mcleod@kerrigan.com. Happy to have you send us a question or comment either through text or through email. Okay, let's run through some of these questions that I think could benefit more than just the caller or texter. First, do I have to give a recorded statement to the insurance company in a car wreck case? So I think the answer to that is it depends. So if this is your own insurance company who is requesting that you give a recorded statement, I think that in most automobile insurance policies, you agree to assist the insurance company in gathering information about any accident where they are presented with a claim. And so if you are involved in an accident, and even if you're the injured party, I think you have an obligation under most insurance companies to give a recorded statement to your own insurance company because of that agreement that you made when you took out your contract of insurance. And so typically your insurance company might be interested in how the accident happened, if you were injured, and what your what your symptoms were. A lot of times they have a list of questions. It's kind of a boilerplate list of questions that the claims handler or this person who works for the insurance company will go through about whether or not you've been in an accident before, have you had symptoms or problems before, and kind of rummaging around your history to see if there's a potential, I think, defense to the case. So if it's your insurance company, you, in most cases, I think, have an obligation to give a sworn statement to your own insurance company. Now, if it's the other person's insurance company, let's say that you're tootling on to work and somebody pulls out in front of you, there's a bad accident, you're injured, and the other person who caused the accident is insured by an insurance company, and that company calls you and says, hey, Mike, we want you to give a recorded statement about the accident and your injuries. So I think that if you have no injuries, if you're not injured, if it's a question of property damage, your automobile was damaged and needs repair, I think that it's okay in those circumstances to give a statement to the other person's insurance company. And that is particularly true if it's a simple accident, like a rear end collision. There's no doubt the other guy rear-ended you, or there's no doubt the other person ran a red light. If it's just clear cut and the issue is over property damage, I think that it's okay and maybe even helpful to give that statement. But if you or a member of your family or someone in your automobile was seriously injured in the accident, then I think that it's very common for the adverse insurance company to want to take your statement and to probe how the accident happened. How fast were you going? Did you have your seatbelt on? Why didn't you have your seatbelt on? If you have neck and back problems after the accident, you've treated at the emergency room or been referred to a physician for treatment of your neck and back pain after an accident, they'll want to ask, have you ever had any of these problems before? Have you been in an automobile accident before? I do think, as an aside, that these insurance companies share all this information with each other to potentially defend cases more effectively. But so you are not obligated to give a statement to the adverse insurance company. And so I think that if you're unsure about the seriousness of your injuries, if you're treating with medical providers for injuries from the accident, and certainly if you're considering hiring a lawyer to help you, to represent you in a case, I would decline giving a statement. And I would just simply say, and this is what we tell our clients, if the insurance company for the other driver calls you, just say, we're thinking about hiring a lawyer. I'm still treating. I'm not in position to give a statement right now, or I've just hired a lawyer. And so you'll have to talk to that person, that lawyer, him or her, about whether or not I will give a statement. So I would push back about giving a statement to the other person's insurance company. You don't have to do it. All right, let's see. This question is, will I have to go to court for my Florida auto accident case? Will I have to go to court? So the clear answer to that is no, you don't have to go to court. And I will say that if you're injured in an accident, let's use an automobile accident as an example. Really, a lot of those cases, the great majority of those cases are settled without going to court. And by going to court, I take it to mean filing a lawsuit, having your deposition taken, and ultimately having a trial about the facts and circumstances of the accident and your injuries from the accident. And so some cases go to trial. We think that it's important for lawyers who do this work and who specialize in accidental injury cases to try cases. That's the ultimate way to settle a claim. And certainly insurance companies who know who your lawyer is know the lawyers that will try a case and lawyers who will never try a case. And it's the lawyers who have a history of trying cases to verdict and keeping those verdicts on appeal that get a better settlement for their clients, because an insurance company who knows lawyer A is never going to try the case will not offer what the case is worth. So quick answer to that question, no, it doesn't mean you have to go to court. A lot of cases get settled before going to court, before filing a lawsuit. And then even after filing a lawsuit, a lot of cases get settled before a trial We've talked a lot about mediation. Mediation is very popular in Northwest Florida. It's very popular with the judges in Northwest Florida. And the reason is because mediation gets a lot of cases settled. It helps judges get their case docket resolved in a way. And then a lot of times it's just better for the parties. When you try a case, very typically somebody's unhappy, somebody's happy. In mediation, the two parties mutually agree with the help of a mediator to a mutually agreed upon settlement. And sometimes that's kind of the fairer result. Not always, but you don't settle your case at mediation unless you agree to it. All right, let's see here. What are subrogation rights? I assume it does. Subrogation has a role in personal injury cases, and I assume that's what is meant by this general question: what are subrogation rights? And the way it is involved in our cases is this. If we have a client who comes to see us who's injured through the fault of another person or business, then we will assert a claim and a case against the party and their insurance company, or the business and their insurance company that caused our client's accident. But as a result of the accident that caused an injury, typically the client's either health insurance company or Medicare or sometimes Medicaid will pay the medical bills that are incurred as a result of the accident. And so let's just use Blue Cross Blue Shield, for example. If we have a client who has $50,000 of medical bills paid by Blue Cross Blue Shield, then Blue Cross Blue Shield also has a claim against the at-fault person, an insurance company who caused the accident. And they have a legal right to recover that money that they had to put out to treat our client as a result of the negligence of another person. And so when we settle a case, Blue Cross has a right to recover the money that they've paid on our client's medical bills out of the recovery. It's something that we agree to when we take out health insurance. It's sometimes a surprise to clients, so we like to give them a heads up before we get involved in the case. But it's also a factor that goes into, well, how much is a case worth when it's settled? We want to know, well, what is the client going to have to pay back to their health insurance carrier? Sometimes doctors will have remaining bills and there are arrangements made for the doctor to keep treating people, but they'll be paid at the end of a case sometimes. So those subrogation rights are important when it comes to the bottom line. What is the client going to net at the end of the case? So it's something that we pay particularly close attention to. I've got some more questions here. I didn't get through all of them, and we're running out of time on the show, but we'll get to them next week for sure and add the new questions as well. I'm Mike McLeod. I'm here for all the lawyers with Kerrigan, Estes, Rankin, McLeod, and Thompson, and we'll be back on the Law Show next week.